This video delves into the most famous privacy cases adjudicated by the ECJ, highlighting their implications and the evolving landscape of privacy rights within the EU and beyond. Google Spain SL, Google Inc. v. Agencia Española de Protección de Datos, Mario Costeja González, 2014. The birth of the right to be forgotten. Perhaps the most widely discussed case in the realm of digital privacy, the ECJ's ruling in Google Spain established the right to be forgotten. This groundbreaking decision allowed EU citizens to request search engines to remove links containing outdated or irrelevant personal information. The case underscored the tension between the public's right to information and individuals' privacy rights, setting a precedent for how digital platforms manage personal data. Digital Rights Ireland Duited, 2014, striking down data retention. In this pivotal judgment, the ECJ declared the EU's Data Retention Directive invalid. The directive had required telecommunications operators to retain user data, aiming to assist law enforcement. However, the court found it disproportionately infringed on individuals' privacy and data protection rights, lacking sufficient safeguards against abuse. This case emphasized the necessity of balancing security measures with fundamental rights, influencing subsequent data retention policies across the EU. Schrems I and Schrems II, the transatlantic privacy battle. Maximilian Schrem's legal battles against Facebook have profoundly impacted international data transfer mechanisms. The first Schrems case, 2015, led to the invalidation of the Safe Harbor Agreement, which facilitated EU-US data flows. The subsequent Schrems II ruling, 2020, further disrupted transatlantic data exchanges by striking down the EU-US Privacy Shield framework, citing insufficient protection against US surveillance practices. These cases have prompted ongoing negotiations for a robust framework that aligns with EU privacy standards. Wirtschaftsakademie Schleswig-Holstein 2018, expanding the scope of data controllers. Addressing the responsibilities of entities that process personal data, the ECJ in Wirtschaftsakademie highlighted that operators of Facebook pages, alongside Facebook itself, could be considered joint data controllers. This interpretation broadens the scope of accountability, impacting numerous organizations utilizing social media platforms for business activities, and underscores the shared responsibility in ensuring data protection compliance. La Quadrature du Net and others, 2020. National security versus privacy rights. This collective of cases further scrutinized the balance between national security interests and privacy rights, reiterating that general and indiscriminate data retention contravenes EU law. It clarified conditions under which targeted data retention might be permissible, reinforcing the principle that interventions in digital privacy must be necessary, proportionate, and subject to judicial oversight. Teletusverige ABV Postdoc Telestyrelson and Secretary of State for the Home Department, v. Tom Watson and others, 2016, affirming the limits on data retention. These consolidated cases address the extent to which governments could mandate the retention of data by telecommunications providers for law enforcement purposes. The ECJ held that legislation requiring general and indiscriminate retention of communications data violated the fundamental rights to privacy and data protection. This judgment underscored the necessity for any data retention measures to be strictly necessary and proportionate, and it set stringent conditions for access to retained data, reinforcing the protections afforded to individuals under EU law. Riga Satixme, C1316, clarifying personal data in publicly accessible registers. In this case, the ECJ provided valuable insights into the definition of personal data within the context of publicly accessible registers. The court concluded that information, including names and identification numbers, which allows individuals to be identified, unequivocally constitutes personal data. This ruling is significant for public authorities and private entities managing such registers, emphasizing the applicability of EU data protection standards to publicly available information. Fashion ID GmbH & Co. KGV Verbraucherzentrale NRW EV 2019, Joint Controllership and Third-Party Embedded Content. Further elaborating on the concept of joint controllership in data processing, this case examined the responsibilities of website operators embedding third-party content such as social media plugins that collect personal data. The ECJ ruled that website operators and third-party providers are joint controllers regarding the data collection phase. This decision has broad implications for websites utilizing third-party plugins, clarifying the scope of their data protection obligations and the need for explicit consent from users. Planet 49 GmbH C67317 consent through pre-ticked checkboxes. This case addressed the validity of a consent obtained through pre-ticked checkboxes for storing cookies on users' devices. The ECJ ruled that such a method does not constitute valid consent under EU data protection law, as consent must be an active, affirmative action by the user. The ruling clarifies the standards for obtaining user consent in the digital environment, reinforcing the importance of clear and unambiguous consent practices. Conclusion: the ECJ's jurisprudence in privacy and data protection matters has not only shaped the legal framework within the EU, but also influenced global discussions on privacy rights in the digital era. By navigating the complex interplay between individual rights, technological advancements, and public security concerns, these landmark cases underscore the EU's commitment to upholding fundamental rights in an increasingly interconnected world. As digital technologies continue to evolve, the ECJ's role in interpreting and enforcing privacy standards remains crucial, guiding the future direction of data protection legislation and practice, both within the EU and internationally.